Hello everyone, my name is Roman David. I'm the Chief Editor of Football Legal, the journal dedicated to football law. Welcome to today's AIAF webinar. Today, tomorrow, and on Thursday, the AIAF will hold brand new AIAF webinars on the topic of post-COVID-19 football. Specifically, we will look at the issue of legal certainty in football today and tomorrow. Legal certainty is a key value. It must be as effective as possible to limit legal risks. The health crisis that the world has been experiencing has changed football. Maybe not a revolution, but at least a big step forward nevertheless. We're expecting a lot of participants today, so we will therefore wait a few moments before starting the discussion, which today bring together, for the beginning, Patricia MOYERSOEN, a lawyer in Paris and the president of AIAF, the Association of Football Lawyers, and Emilio GARCIA, Chief Legal and Compliance Officer at FIFA. Afterwards, two roundtables will be proposed. The first will deal with the issue of competition and their termination, suspension, or resumption. There are many legal challenges on the subject. In the second, our speakers will provide details on the current legal challenges. Well, first, I would like to warmly thank our speakers today for taking the time to come, explain, debate, discuss the issue of football law. So thank you to all of you. Many thanks also to all those who are joining us. I see people from Paris, Zurich, of course, Buenos Aires, Edinburgh, Madrid, Montevideo, Lisbon, Casablanca, Istanbul. Well, welcome to all of you. Thank you very much. I propose that we begin now the session. Patricia, Emilio, you have the floor. But first question, how are you?
Fine, fine. Thank you, Ronan, to introduce this second run AIAF webinar. So just few words for those who are not familiar with AIAF. AIAF is an association who gathers 110 around lawyers coming from all around the world, 35 countries, actually, the 5 continents. AIAF is a forum for sharing knowledge, for debate, for sharing experience, and all as lawyers were very keen to not only share between us, but also with worldwide football stakeholders. So each year AIAF organizes a Congress. This year should be in Brazil. It will be next year in Brazil. And since we cannot be all together in the same place, we started session, AIAF webinar session. And it's very interesting. We are very happy to have all as participants and speakers in this second session. So as Ronan explained, we will have tonight one session, tomorrow another session, and on Thursday a Spanish session. And I'm very proud now to organize a Spanish session. Maybe once we will have in French, but Spanish is a very important language in football. And since Spanish, thanks to Emilio, now is an official language, and it's important for AIAF to be able to share and to work in Spanish. So I would like to thank our guest speakers, FIFA, with our friend Emilio, Erika, MONTEMOR, FERREIRA, Ornella Desiree, Belia, James Kitching, fantastic team who will be with us in these 3 days. CONMEBOL with Montserrat Jimenez. I'm very happy to welcome her for tomorrow, Thursday session in Spanish. FIFPRO with Alexandra Gomez, Roy VERMEER, Loïc ALVES. Thank you very much to be here with us. World League Forum with Jérôme PERLEMUTER, who is with us too, and Roberto Branco Martins from EFAA. So we have the main stakeholders, the core stakeholders of football with us, and it's fantastic because it gives us a great opportunity to debate. So as Ronan explained, participation is expected. AIAF is not academic tool. It's a tool to participate. So do not hesitate to ask questions, to give your view. You all know now the fantastic tool you have to be able to ask questions and to debate with us. I would like also to thank Ronan and our partner, Football Legal. They are doing a fantastic job to organize this webinar, to contact all the speakers and to prepare with us this session. So let's go inside. So FIFA is at the heart of the legal system. So we are going to focus on legal certainty of the football, worldwide football, today and tomorrow. At the heart of the system, you have FIFA. FIFA regulates, FIFA monitors, FIFA judges, huge powers in the same hand. But as we've seen all, the system is improving a lot for many years. Improving in the sense of the separation of the powers, improving in independence, improving in transparency, and improving in more cooperation. I think that one of the architects of this evolution is our friend Emilio GARCIA SILVERO, FIFA Chief Legal and Competence Officer. I can see that through first the first document issued by FIFA on April, the guidelines, then after the Q&A issued on 11th June, and the third act was the FIFA Football Law Annual Review last week, which was very interesting with a lot of figures. We could see that for sure FIFA now is working with cooperation with the stakeholders and also with a lot of transparency, a lot of open debates, and AIAF is the right place to debate. So Emilio, I'm very happy to have you on board. You know that today for our English session and on Thursday for a Spanish session. I know that in the Spanish session you will be very active, and I would like to thank you very much for your participation. Now it's time to debate, and I know that all our friends, Emilio, all the FIFA team and the other stakeholders are open to debate with us, the football lawyers, open to debate with all of you participants, even if you are students or inside a club or a player, open to share and to ask questions and to share your views. So please use the tool who allows you to debate with all of us and with our guest speakers. So now I hand over to Emilio, who has accepted to kick off this AIAF webinar. So Emilio, the floor is yours, and thank you very much.
Merci beaucoup, Patricia. Thank you very much. Good morning for those who are in Central America, North America, or South America. Good afternoon here in Europe, in Africa, and those who are maybe in the Asia or Pacific. Good evening, buenas tardes, buenos días. First of all, I would like to start by saying thank you to Ronan and Patricia for having considered us, FIFA, as potential speakers in these seminars today, tomorrow, and on Thursday with our Spanish speakers in South America and Central America. It's a great pleasure to be here this afternoon, and of course a big pleasure to have the opportunity to interact not only with you, also with all the participants. You know, the topic of these webinars is, as you advanced, Patricia, legal certainty. And I would like to start by emphasizing that unfortunately legal certainty doesn't exist. At least during these days, particularly since this COVID-19 outbreak destroy our lives, first personal lives and also professional lives. As you know, and as you advanced in the beginning, we have been very active dealing with the legal consequences of the COVID-19 outbreak, particularly on the transfer market. And of course, FIFA is not a perfect organization. We are very far from being perfect. But what I can say is that at least we have been very proactive since the beginning. And this is thanks to the excellent cooperation with the so-called football stakeholders, but the colleagues that are also involved in football. So the World League Forums with Jérôme, FIFPRO with Alexandra and Roy, and the European Club Association, Jose Luis Iran. So, you know, if you ask me, when on the 18th of March 2020, the Bureau of the FIFA Council decided to set up a working group to address the consequences of the COVID-19 outbreak on the transfer market. To tell you the truth, at that time I was, you know, how can I say, I was really reluctant and I was really cautious about the outcome of the meetings and the outcome of these potential quick reforms. So thank God, right now FIFA does not govern the whole world with the ring. So, you know, we need to respect different laws and regulations in different jurisdictions. That's why the situation is not like 34 years ago, in which FIFA decided to impose something and then the contract or the decision can be enforced in Spain, France, or Argentina in 2 minutes. Right now, as you know better than me, all of us, the situation is not like in the past. That's why I was a little bit cautious in the beginning with the expectations when the Bureau of the Council again decided to set up this task force. But over the last 3 months, 4 months, I realized that even though I was cautious, now what we have published and what we have decided to implement and propose in different jurisdictions works and works very well. So obviously the two documents issued by FIFA, wouldn't like to say issued by FIFA because in the end it is a document negotiated and agreed between the football stakeholders. FIFA is just one, but we agreed the document with World League Forums, we agreed the document with FIFPRO, with ECA, with the Confederation. So that's something that cannot be possible if we don't cooperate. And maybe in the past, you know, I tend to say more and more that the transfer regulations, the so-called regulations on the status and transfer of players are not anymore regulations. The regulations are kind of a sort of CBA, collective bargaining agreement. And this is good. Sometimes it's challenging because, you know, you need to negotiate everything, particularly with, for instance, Jérôme. I see Jérôme on the screen. So he's super French and you need to negotiate everything. Then we have your friends from FIFPRO. So, you know, they are looking at the comma and the full stop, and they're looking at the 0.3, 0.2. ECA, of course, they have their own interests that we should respect and we respect, obviously. So it's challenging, but obviously then the outcome is better because it's the agreement of all the football stakeholders. And again, I would like to emphasize since the beginning, the success of the document, or at least the positive aspects of the two documents, is thanks to this cooperation between football stakeholders. For me, it's really a pleasure to see that when I thought on the 18th of March with the FIFA team, with James, with Erika, with Ornella, what can we do in order to solve this mess, this completely crazy situation? Now is a pattern in some jurisdictions, and particularly in some jurisdictions in which employment law or in which the role of the state in football matters or sports law matters is really, really, really powerful. So it's amazing to see that, for instance, in Argentina, in which they have a CBA since more than 50 years and regulations for everything, or in Brazil, or in Spain, or in a certain way in England or in France, these guidelines for FIFA are part of the structure or part of the solution. And I tell you the truth again, so that's something that I would never predict in March. So the original idea is to help some other jurisdictions in which players are not protected. They don't have civil law or employment law to protect the relationship between players and clubs. But then you see that in many jurisdictions all across Europe, the most sophisticated jurisdictions, they are more or less happy towards the FIFA system. And I think that's something that we did and we emphasize since we published the first document, that is, we should respect domestic law and we should respect the autonomy of the parties. Something that, again, we really, really emphasize. FIFA is not above the law. And, the first thing that you have to do is to respect domestic law, and the autonomy of the parties was really, really well received. I think that if we have followed a different approach, something like these are the rules of FIFA and you need to comply with this, this is something that will never fly. But thanks to this approach, I wouldn't say conservative, I would say practical and realistic, that, hey guys, we cannot solve everything. So FIFA is FIFA. So we know how to organize more or less the World Cup and some other tournaments, but we cannot impose employment law in Bolivia or in Vietnam or in the Netherlands. So I think that this approach was very well received. And the outcome is there, as you know better than me. On the first week of April, if I'm not wrong, on the 7th of April, we issued the first guidelines. These are not regulations, they are guidelines. After that, we opened a debate again with the 211 MAs. We went through different webinars, Zoom meetings with all MAs and legal counsels, also with the clubs. More than 120, 130 clubs from ECA, also with the leagues, 20, 30 leagues with Jérôme. So over 40, 45 days from the first week of April until the last week of May, we went through this consultation process, and the consultation process ended up in this Q&A document, again, agreed between the football stakeholders. Again, well, the 3 or 4 different topics that we tackle. The first problematic that we face was how to deal with these expiring agreements linked to the famous date of 30th of June. So how can we solve this? Bearing in mind that the competitions will move ahead and were suspended at that time. The second point is how to deal with agreements that cannot be performed as the parties originally anticipated, obviously due to the COVID-19 outbreak. The third problematic that in the beginning I thought, well, this is simple to solve, and then became the most tricky one, was how to be aligned and do our best concerning the transfer windows in all continents and the relationship between Europe and particularly South America. And then the fourth topic is what we call other football regulatory matters. And here there is an amalgama of cases and situations. And if I have to highlight something is the FIFA Council, and I think that all the stakeholders were happy to put on hold the new loans regulations. As you know, a few months ago, the FIFA passed some decisions following the consultation process with the stakeholders to put some limits on loans. We think that this is the right way, but bearing in mind the COVID-19 outbreak, we decided again to put this decision on hold. COVID-19 is affecting all kinds of activities all around the world, football, of course, FIFA as well, but there are some projects that have, in principle, have not been affected by COVID-19. In here, I refer, for instance, to the FIFA clearinghouse. So we are still convinced that we can start running the project and opening the doors of the company as from 1st January 2021. We are fully committed here to do this, the whole team from the football regulatory subdivision. Of course, there are some challenges ahead, also COVID, but there are some projects that continue even though we are all living in an unprecedented situation, working from home, most of you, most of us. So these are the main questions that we tackle, these 4 points, first in April, then in June. And again, I would like to highlight today that, and we will have 2 days to debate the document, the consequences, but it's important for me, again, to emphasize that the documents are not solving and will not solve all problems around the world. And I think that FIFA and the football stakeholders, we are very well aware of this. So, you know, we cannot solve 1,225 problematics because first we don't have the tools and we don't have the competence to do this. But all of us, again, FIFA, FIFPRO, the clubs, the leagues, and the confederations, we are trying to do the best to be reactive, to be close to the MAs, to be close to the clubs and leagues in order to solve these problems. I'm not an expert. It's difficult to say to what extent COVID-19 will be there, particularly in the football market. But I would say that the consequences of this outbreak will not finish on the 1st of September. So, you know, here in Europe, we go on vacation, more or less. So summer, and after summer, everything is back to normal, and we will continue. I think that, you know, the consequences of the outbreak will be there for the next 2 or 3 years, not only from a legal standpoint, also from a sporting standpoint. So the international match calendar is heavily affected by these 3 or 4 months. And the international match calendar has an effect on everything. So again, at this stage, difficult to see the end. But the most important thing that we are all here fully committed to do our best to solve the problems. I'm sure that after summer, after the new season restarts in October here in Europe, we will face more problematics at Christmas, after Christmas. Of course, COVID-19 has also affected the work of the Football Stakeholders Committee, the task force in charge of the transfer reform package. We were close to start negotiations on the buyout clause, the so-called fiscal regulations. We were very close to start negotiations on the transfer of minors. We were close to start negotiations on the squad limits. And of course, this situation has put on hold on all these projects. The idea from FIFA is to start working on all of these ideas as from September. But again, we don't know the final consequences of the outbreak. There are 2 other points that are not related to the topic that we are addressing today, COVID-19, these guidelines, the Q&A, but I would like to announce here, we also announced this at the last meeting, I think, of the task force. So we are also working on 2 different important aspects, and I think that Alessandra is connected and would love to hear this, even though we have a brief conversation by email a few days ago. We would like to include or amend a little bit the transfer regulations in order to create a particularly legal regime for women's football. So women are not men, that's obvious. And from time to time, they need a different kind of protection. And I think that we need to adapt the transfer regulations to the reality, to 2021. So we have a working document that we would like to present to the football stakeholders soon. If we reach an agreement, if we move forward with this, hope that in 2021, we will see some amendments to the transfer regulations in the area of women's football. Again, right now the system is not perfect and we need to be quick with this. And the second area in which we would like to move forward, apart from COVID, apart from transfer windows, squads, limits, minors, etc., 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 is protection of coaches. You know that the Player Status Committee, the committee is dealing with coaches, but in a certain way. And of course, the FIFA transfer regulations are not adapted to this. So we would also love to see some amendments to the transfer regulations in order to better regulate the coaches' atmosphere. Again, we should do this, and we are going to do this in combination, in cooperation, and with the agreement with FIFPRO, ECA, and the World League Forums. But again, I hope that in 2021, these changes will come into light and we can adapt a little bit the transfer regulations, at least in these two particular areas, even though we are, and we will start working with our colleagues as from September on the other main topics. That's all from my side, Patricia. I think I don't know if I have to speak more than 20 minutes, 30 minutes. I've seen a list of more than 136 participants. 95%, if not 100%, they know better than me this, and they have more knowledge than me. So it's better to stop here and to listen from others who know better the system than me. So if you agree, I stop here and I will continue to listen.
Thank you, Emilio. Thank you. It's very clear. And I think we all realize how useful was the documents issued by FIFA, because it gives us as a lawyer a fantastic tool, a tool to assist our clients, a tool who allows us to give advice, but also to challenge some decisions taken in the national each country. So these are tools, and I've seen that mostly FIFA gives recommendation. It's not strictly regulation. And there was also I think that also FIFA focus on good faith and bad faith in the negotiation. And I think this is also useful to assist our clients, saying that facing this outbreak, facing COVID-19 needs cooperation, needs good faith, and bad faith should be sanctioned in good faith. This means also that the regulation cannot be applied and enforced totally strictly, because facing this amazing situation, a lot of clubs, a lot of players had to go forward and to go forward without knowing what's going to happen. So it was very useful, and I think that to have the possibility to debate with us and to debate with you, with all stakeholders, give us as lawyers, but also for the clubs, for agents, a very interesting tool. So thank you, Emilio. We are going to go on the first roundtable. Just few words, one word, Emilio, to say that I'm very proud that in this webinar, we have a little bit more than 30% female speakers. And as you know, I am very, I think it's very important, at least we have at least one woman per roundtable. Thanks particularly to FIFA, who have a lot of female in your team. So this is very important for AIAF for the diversity, having more female involved in football law. So let's go for the first roundtable. If you, Ronan, is there something I can go directly to the first roundtable?
Go ahead, Patricia.
Okay. Okay. So, first roundtable, we are going to focus on competition, okay? So, competition means that, as you all know, for the very first, can you hear me? Yeah? Okay. For the very first time since World War II, all the football governing bodies were forced to suspend competition everywhere in the world. So after a long time of suspension, now the same governing bodies had to take decision on whether to stop or resume the competition. Many questions arose around these decisions. First, who has the authority to make that decision, depending on the country? But also, what criteria were taken into consideration by these governing bodies to justify their decision to stop or to resume the competitions? And criteria, I think there are 3 criteria. Sporting criteria, these decisions had to respect the safeguard integrity of competition. This is the first criteria. But there is also the health criteria, players' health, staff health, the fans' health, so second criteria. And the third one is the economic criteria. There is a very important economic issue by facing this situation of COVID-19. So in several countries, depending on the country, some decisions have been challenged or are still challenged in court. So I would like to first give the floor to Jérôme, because I think that Jérôme has a view of the whole world situation facing to this question: who decides to stop or resume, and what were the first criteria, sporting criteria, taken into consideration, and what are the challenges now on board facing this decision? So, Jérôme, you have the floor.
Thank you very much, Patricia. First of all, thank you also, Ronan, for organizing this and for the invitation. Very glad. And thanks to the FIFA friends for the kind words and the work we've done together. To answer your question, Patricia, yes, I think you're perfectly right to stress how different situations are from one continent to the other, and also within the same continent, situations are very, very different from one country to the other. So as the World Leagues Forum, we have more than 40 members. I think we have a kind of clear view on how the world of football is suffering, because it's not the past tense that we should use now. It's really the present tense and also the future tense, because here many of us are in Europe, where most leagues have resumed, and hopefully they will not have to stop again. But in the rest of the world, the situation is not alike. So the first thing is, you're right, all leagues around the world had to stop, except like maybe 3 or 4 very specific examples. All leagues stopped. And I speak of top divisions because those are my members, but all of them. Now, in terms of where we are on the resumption, in Europe, most of the leagues have resumed now, except 6 who have decided to stop. 6 of them, which are Azerbaijan, Belgium, France, the Netherlands, Northern Ireland, and Scotland. But all the others have resumed. In the rest of the world, it's very different. In Africa, none of them have resumed, none. Morocco is training again, but as far as I know, they're the only ones. In Asia, it's a bit better with most of the leagues, I mean, not most of them, but many resume training, and some have already scheduled the resumption. There's one league, and we've heard about it, it's Korea, South Korea, I mean, who resumed before everyone else on May 8th. And in Central America, the health situation is not good. Only Costa Rica resumed, but the rest have had to stop and are still stopped as we speak. And in South America, it's a bit of the same situation. So you see, we need to be careful with our European-centered eyes, because the situation is bad. Leagues are suffering, and without going more into the aspect that, because we will discuss it, of sports, health, and financial situation, I think the first aspect was really that of health. Whether can you play in a situation of this pandemic, or can you not? And health, in all cases, was the main aspect that was considered, whether to stop or to resume.
So we know that some decisions are now challenged in different countries. One of the countries where the decision has been challenged, because there are the decision to stop or to resume, but also the league had to take decision on the final standings of the competition. If you stop the competition, what are the final standings? And the relegation and promotion. So it's very complicated, even could be more complicated to stop than to resume. Because if you stop, you have to make decision on the whole pyramid, from amateur to the top level, about the final standings, and then regulation and promotion. And that would be considered as unfair by some. So Pedro MACIEIRINHA, I have a very good, it's so difficult to spell your name. He is an AIAF member and a lawyer in Portugal. And Pedro, can you tell us and what's going on in your country, please?
Of course, Patricia. First of all, my compliments to everyone here in the panel and outside that are assisting us. I want to say that when we have to take some decisions, some hard decisions like these ones, what the public and the stakeholders expect is consistency. And in the Portuguese case, we don't have this consistency. We have 3 leagues, 2 professional leagues and 1 amateur league, and all the decisions in these leagues are different. All the decisions, we have the first league, Portuguese first league, that resume already, and they are trying to finish the championship, and I think they will. We need more for games to finish this season. And we have the second league that is a professional league too, that don't resume. The league decide to stop, and the board of the league decide on 2 relegations and 2 promotions with the stands that they have on the 2/3 of the championship. Of course, that the clubs that are affected with this measure, they don't accept it, and they are challenging this decision on the courts. And we have the third league that is an amateur league that the federation decided to stop because they think that they have no conditions to restart with the questions about the problems with the COVID. And they decide that nobody relegate, and they promote two by merit reasons. Normally on this third league, you have a playoff by 8 teams. In this case, they go to the first 2 series, and they choose 2 to be promoted. Of course, that the other 6 that are in the same position and that is applying for the playoff, they are not happy, and they are fighting on the courts this decision too. So we have a lot of issues, legal issues now, because of this. I think not this question about consistency of the decision, because if everybody accept that you give one decision for all, and in this case you have different decisions from each level, and you cannot understand how the second league is a professional league, and the reasons to not restart, not resume, are different from the first league. Of course, that we know that the first league have more revenues, and it's easy for them to pay all the extra costs of the measures that the public health have implemented to restart the games. We are restarting the games without public, as in all over Europe, but they have a lot of tests to do. They make 3 tests in between every game. They have to make 3 tests, and as far as we know, we have no problems. We have only 1 case of a goalkeeper that accused positive in the day of the game and cannot play. Yesterday, 1 referee that accused positive on the day of the game and have to be substitute. The rest have been professionally work. So that's why the clubs from the second league don't understand why they cannot play if they have the same professional structure than the clubs of the first league. They are obliged at the same to have a doctor, to have nurses, everything at the same. So they want to play. Of course, everyone want to play, and they have this administrative decision to relegate and promote with 12 games left. It's very, they are challenging this now in courts, of course, and we don't know if the league will restart again at the point, because we have caution measures that they have request to the court to not to restart the new season, and we don't know how they will solve this. Of course, that this bring a lot of problems to these small teams too, because they are almost 6 months without competition. They have to pay to the players. They have professional players on the second league. Even the amateur players, they are not competing, and you have a problem now to restart everything. And we have the loss of all the revenues, because they live with the tickets that they sold to the games that they are forbidden to sell. We have the problems with the sponsorships that they give money for, put an announcement on the field for 1 year, and now they don't have games. They have a lot of financial issues that I think it was the one thing that concerned the board of the league when they decide to resume the first league, because our first league, as you know, we have 3 big clubs and the rest are very small clubs with small revenues, but all the clubs facing a lot of problems with the cut that the operating of TV rights, they stopped to pay when they stopped the games, and everybody was facing really financial problems. And if they don't resume, maybe most of the Portuguese teams from the first league face insolvency. So they have, not because, in my opinion, not because of the health conditions, not because of any other, even the integrity of the competition. The main decision from the board of the league to restart the first league was the economical issue that can bring great consequences to the well-known clubs from Portugal.
Thank you, Pedro. I think that we will come back to the financial issue. So Christophe Bertrand, he is a French lawyer. He is a member of the board of AIAF, and he knows perfectly, because he is a lawyer of clubs, French clubs, who are not happy with the decision. So Christophe, you have the floor if you can give quickly a view on what is going on in France. Thank you very much.
Thank you, Patricia. First of all, thank you for AIAF. Thank you also for Football Legal for the invitation, and I'm very pleased to be here with all of you, and I hope everyone is doing well right now. To give you a quick view of the French situation is going to be not that easy, because there were about at least 50 procedures launched in France. I was in about 2/3 of it, so it was quite complicated. And to understand why those procedures were launched and went before the French Administrative Supreme Court, you must understand, first of all, a few points. The first ones are that in France, we were confined from March 17. Everyone was confined from March 17. And the confinement was, by the government, decided to go back up to March 12. From then, all sports, all French federations decided to stop the competitions, mainly, let's say, and let's admit, for healthy reasons. Football was a little bit different than other federations, because it was one of the only one federation that decided to still have promotion and relegations, even though the competition was stopped and was final. I think the only other professional league that did so was volleyball. But all other sports, professional and amateur, decided at least not to make relegations, to have relegations, because of the competitions that were stopped because of COVID-19. The second point that you must know is that in France, we have a system a little bit different, maybe, than in other part of the world, is that the French federations for all sports have, by the government, a public service delegation given to them to organize the competition. That means that all the decisions made by a federation on the competitions and on the organization of the competition, if you want to challenge it, you have to go before the administrative court. So knowing that, the French Football Federation decided on April 16 to, as I said, stop the competition with no resume possible at any point of time. They decided not to change the end of the season, which in France, is on June 30th. And by the way, not changing the end of the competition of the season in France made some other difficulties for the players' contract in regards of the Cups finals and in regards also of the Champions League. Because of course they're going to play in August, and because they didn't move the end of the season, it made some difficulties in France because of that. So the French Federation on April 16 decided two things: to stop the competition, to have ranking based on a ratio, which was basically the points the club had divided by the games they played. And in case, third thing they decided, in case there was a draw between two teams, they decided of new rules to be able to separate the teams. Based on those 3 points, the French Federation decided that for the national amateur competitions, there were going to be 3 relegations and only 1 promotion. And for all other amateur competition, 1 promotion and 1 relegation, and no playoffs at all in any competitions that were playoffs, that had playoffs. Based on that decision made by the French Federation, the French Football Professional League which depends of the French Federation, decided on April 30th, exactly the same thing for First League and Second League, with relegations and promotions, 2 promotions and 2 relegations per division, and also no playoffs. Many clubs, amateur and professional, considered those decisions were unfair and against the integrity of the competitions. On the amateur clubs, there were about 50 cases launched that went before the French Olympic Committee, and about 30 of it that went before the Administrative Supreme Court, which was competent to deal with the decisions made. And I didn't say it, but both decisions were made by the Executive Committee of the French Federation and of the French Professional League. And the court said, as the rules decided by those Executive Committee were general, it is directly the Supreme Court, the French Administrative Supreme Court, that is competent to deal with those decisions. So there were about 30 cases of amateur clubs before that court. And as we're speaking now, there were, on professional club, there were 3 clubs in First League that challenged the decision, which were Lyon, because they were not part of the European competition as they were ranked 7. And also the 2 last clubs that were relegated from First League to Second League. In Second League, there were 5 clubs that challenged the decisions. The 3 ones that were supposed to be able maybe to play the playoffs, maybe to promote in First League, and also the last 2 clubs that were relegated from League 2, Second League to the amateur division, 3rd division. And there are also other cases to come, which are probably the 3rd team of the 3rd division that considers at least that he should have played the playoffs to enter Second League. So not all decisions have been rendered yet, but at least we have 3 decisions. The first one is the decision that was made by the Conseil d'État, which is the Administrative Supreme Court, on June 11th, which considered that, yes, the Executive Committee of the French Federation was competent to deal with this situation based on what the French Federation called the intérêt supérieur du football, which could be translated by superior interest of football. Secondly, the Supreme Court said that the choice of the Federation to either resume or stop the competition and to make promotion and relegation, it depends to the Federation. It is up to each Federation. It is into their power to do that. The power of the judge is only to verify and to make sure that the process of those decisions were correct and not illegal, but not on the choice itself. On the amateur division, there were some competitions that were not even played at 50%. And even some competitions were not even played up to 50%, and most of them were played between 50 to 70% only. The judge said that it is not inconsistent or unreasonable to consider that based on the pyramidal construction of all those competitions, that they could have stopped and that they could have made decisions with ranking plus promotion and relegation. The second decision that was given by the Supreme Court was on June 26th, concerning the 3 clubs that finished 3rd, 4th, and 5th of Second League, that was challenging the decision of the French Professional League not to have the playoffs. And once again, the judge said that, at least considered that at the time the decision was made, which was April 30th, it was not unreasonable to cancel the playoffs for the Executive Committee of the French League, because they, at the time of the decision, were not able to know when and how eventually could have been played the playoffs. So the decision was maintained. The third decision that was taken also by the Supreme Court is the decision concerning the French First League, which was rendered earlier than the third one I was talking about, was rendered on June 9, which was actually the first one rendered in all those. But I kept it for the last because it's a little bit different. In this matter, the French professional clubs challenged the fact that the ranking was made, even though only 73% of the competition was played. And once again, the judge already said there that it was not contrary to sports equity, sports fairness, or even to integrity of the competition to have such a decision of ranking based on ratio plus relegation and promotion, even though it was not played more than 75%, 73% to be exact. But the decision was suspended by the Supreme Court because the decision of the French Professional League was made based on an agreement between the French League and the French Federation, saying that for First League, the format of the competition, can I say that? I guess, I hope so, was between 18 to 20 clubs maximum. And if there had to be no relegations, that would have meant that the two clubs coming up promoted from Second League to First League, plus the no relegation of First League, then the competition for next season would have to be played with 22 clubs. And the agreement between the French Federation and the French League says maximum 20. But the French League took that decision based on an agreement that was ending June 30th, 2020. So the judge said, you cannot base your decision on this legal basis that was ending on June 30th to consider that for next season starting July 1st, you could only play at 20 clubs. So the judge said, please readdress the question of the format of the competition once the new agreement with the French Federation and the league is signed for the next period of time, which is 2022-24. And once it is done, please draw again the consequences on the format of the competition and on relegation and promotion. So the decision was suspended. It was a big mess in France for the entire month of June. And the league took some new decisions, which the last one was on June 26th, saying again that now the new agreement between the French Federation and the league is signed based on the calendar and all the competitions for 2021. Sorry, there was the calendars. I mean, all the games are going to be already extremely difficult to put in only one season. So they decided that the format of the competition will stay for next year at 20 clubs. And they decided once again to relegate the last two clubs of First League, which means that at least one club of these last two clubs said that they will continue to challenge that decision, that they will size again and go again before the French Supreme Court, which it hasn't done yet, but will do. And also we're still waiting for some decisions of the Supreme Court concerning the last two clubs of Second League that challenge their relegations. The hearing is on next Wednesday. And also we are challenging now the clubs, and especially the amateur clubs now are starting to challenge the consequences of their relegations with prejudice proceedings, which are starting now to happen in France. So
Thank you.
That was the situation in France. And if you may, one last word, because basically the French football and the court also said that it was not unfair to stop competitions and to have ratios and draw rankings and relegations, even though you have to stop the competition at 50 or 70%. That the question that it maintains then is for next season, what is going to happen? Because next season nobody knows what's going to happen in terms of healthy reasons. Maybe the COVID-19 will come back, and if it comes back, maybe we will have to stop the competition again. We don't know, and it will be interesting to follow that for next season. Thank you.
Thank you, Christophe. I understand it's very difficult to summarize all these procedures, but now it's time to give the floor to FIFPRO, Loïc Alves, because in the middle of this there is health, and players are the most concerned by this situation. So could you give us the view of FIFPRO, and also if you know if there are some players who challenge the decision to resume the competition because of health situation. So Loïc, you have the floor.
Thank you, Patricia. Thank you for having us first. Yeah, I'll try to brush a portrait rather quickly. For the second question, I haven't heard so far of any player trying to challenge the decision to resume. What we've heard, though, is in countries where there is solid social dialogue, our players' unions have been involved, and it postponed the resumption regularly. One could even argue that, for instance, in Germany, they resumed very quickly, but there is no player union as such, so maybe it made it faster in the process. In England or in Italy, we've heard a lot of discussions like going back and forth about the return to play protocol and how it was negotiated. And then to get into your first question, yeah, when the lockdown, I think we have to divide the phases for the players. When the lockdown were decided, very often even leagues or federations were not really involved even in the decision-making process. It was like a governmental decision mainly. What we've observed for our players is that it was very sudden. They're citizens like us, they're individuals, so they faced the uncertainty, especially for players that were abroad. It came out of the blue in some countries, and players, their reaction depended pretty much on the transparency and openness that there was in the governance between the club, the federation, and the league. So the more openness and transparency, the more understanding and certainty players could get when it came to what was the link of subordination that would stay in place during the suspension. What about housing? And then there was some sort of a second phase that came very quickly after this very sudden lockdown. It was the legal questions. So players that had to face clubs where there was not much dialogue, but a lot of letters or texts being sent around about taking a pay cut or going on furlough, it became players developed a sense of anxiety, symptoms of anxiety, and we've seen it through actually a survey that we led. And very quickly, we also saw questions that we had never faced before. So what about a foreign player stuck in X country? Can he or she go home? And under which conditions? What if the club says no? But what if the club is actually trying to get a waiver in exchange of any sort? We've seen, for instance, clubs trying to negotiate agreements under which the player could leave, but could come back, but had to come back. And if he couldn't, even because of borders being closed, would have to face disciplinary sanctions. Or we also quickly touched upon at the beginning women's football. What we've seen also in lower leagues in terms of economics is that players are often paid in kind, be it through accommodation or food. And when contracts got suspended or pay cuts were imposed, and those players with housing were actually left only with housing from the club, which also gives them a very little leverage when it comes to trying to enforce their rights. And I agree with Jérôme, we're facing the same. We're global, so we face a very fragmented industry from the very top to the very bottom. And we've seen dramatic situations in reality where players had to sell food or take, like on the streets. In some countries, they had to receive food packages, be it from unions or from federations sometimes. So it's been quite a challenge to try to answer properly all questions we've received. And then once this lockdown and first round of questions arrived, the issue of governance became prominent, because under which conditions would they return to play? What about at the domestic level? Of course, FIFA or UEFA, they have like solid social dialogue commissions, they introduced workshops, but the reality on the ground was very different. Even when players' unions do exist, the mechanisms to involve them are quite deficient. So what's left then for a player in a country where there's no social dialogue and where there is also no proper NDRC or legal recourse to turn to enforce their contracts, if any contract? So it's been like quite a ride. It's not the end of it. I think we will keep talking about the governance matter and also the economy later on. So yeah, like as an introduction from the player's perspective, this is what we've noticed.
Just before going to the question, Jérôme, would you say that the league who had decided to stop the competition the grounds were health, and the leagues who decided to resume competition was not health grounds, but more economic and financial? So between the two, the health and economic, and of course integrity of competition, how would you say that the decision has been taken regarding which criteria?
Thanks, Patricia. I think it's a very good question, because obviously we need to be careful on the eyes that we have on the financials of football and the economy, because it's not about the top 5 leagues who can live on their media rights, even though they're playing behind closed doors. In many countries, the media rights, they don't reach the level that they have in the top 5 or let's say top 8 leagues. But if you play behind closed doors, you actually lose money every time you play, because you need to pay the players, you need to pay the travels, you need to pay your creditors, but because the TV rights are so low, you don't have the income to face your creditors. So it's true. However, I would say that in most circumstances, it is the health situation and the government's policies which made the decisions, and not the financial situation. If you take a country like Switzerland, it's very interesting, because in Switzerland, the media rights are not very high. And they, most of their income is from the gate receipt. So when they go back to play, they actually lose money. But still, they went back to play, because the health situation was such that it was possible to go back. So they went back. So I would say, although everything that I said, it's really the health situation that made the decisions.
And integrity of competition, because this is the point in France, which has been asked to the judge. So there is one question, Ronan, I've seen that. Could you put Luc Mirac on the screen? He or she is going to ask the question directly.
Luc, we're listening to you.
Mm-hmm.
Go ahead.
Okay. Can you get me?
Yes.
Yes.
Go on.
Okay,
go on.
Good. Yes, I was asking the question to the speaker from France. Christophe Bertrand, who said they can go to the leagues or the clubs or the players or the actors can either go to the French administrative court or the Olympic Committee, and those jurisdictions have given their their rulings on the various judgments on the various issues raised. So I was asking Christophe, can you tell me whether they are using laid down rules or it's just at the discretion of the court?
Christophe, mets ton micro.
Yes, it's better with the mic.
Yeah.
You mean discretion of the judge or discretion of the federation and league?
Well, when the two parties come before
the court,
they raise
reasons why it should be,
well, for example, challenging
of the league. Now
the court
use
in arriving at do they use laid down rule, or it's just at the discretion of the court? The judges they decide based on their own perception of things.
There is an echo. We can hardly hear you.
Can you hear me?
There is a strong echo. Christophe, do you have an idea of the sense of the question?
Yeah, we try to answer. I hope the answer will be what Loïc is expecting. As I said, in France, the French Federation and also the French League, which depends on the French Federation, they have a public service delegation. So the judge is here to make sure that the federation used correctly this delegation, this power, and did not infringe any law in taking their decision. And basically, the French Federation and the French League, both, they said the same thing. They're on the same arguments. They said extraordinary circumstances, and they invoked the superior interest of football, which this notion is as itself written into the regulations of the French Football Federation, which gives the power to the executive committee when the superior interest of football is concerned to make decisions. So they said those extraordinary circumstances justify us to, upon these superior interest that we have to make sure is respected, to take those decisions. And that was exactly what was challenged by the clubs, saying what is the superior interest of football to make relegations, even though we are facing extraordinary circumstances, which is true. That's why we have to stop the competition with no resume. And no clubs challenged that. Maybe one, Lyon challenged it, but all the other clubs, professional and amateur, did not challenge the fact that the competitions were finished and stopped. They agreed with that, but they said, because we have to stop the competitions, even though only 2/3, and maybe sometimes not even 50% of the competition is played, it is against the superior interest of football to have relegations. Look at what other federations decided, no relegations with the exact same situation. But once again, the judge is not there to take the decision, the choice instead of the federation. Is only there to verify that those decisions were correctly decided. Even though the decisions are not correct, it's not this point. The process must be correct, period, for the judge. And in the process, as the process was respected, as far as now, all the decisions said, well, you have to stick with the decisions of the French Federation and the French League. I hope I answered your question.
There is another question from Camby's Héron. Ronan, could you ask if Camby's can come on the floor and ask his question?
Yes, I'm inviting him right now. Camby's, can you hear us? Camby's, used to work for Football Legal, and he's a strong observer of football law. Cambis, can you hear us?
Hi, good afternoon, everyone. And well, thanks very much for putting this on. It's extremely useful. One of the questions I had was regarding governing bodies and competition organizers, whether it would be in their interest moving forward, and obviously for future seasons, but to put in place contingency plans and to prepare for any potential outbreak in the future or any other reason for which competitions might have to be interrupted for a long period of time. If that was to happen again, could we expect competition organizers and governing bodies to put in place some rules to specify exactly what will happen if competitions need to be interrupted for a week, a month, 3 months, so as to hopefully save themselves from having any clubs file any claim against their decisions?
I think it's a very interesting question, because I was wondering what would happen if FIFA would have say, okay, all league, you have to stop right now and you have to decide right now the final standard like this. So FIFA didn't do that, let each league to decide. But looking at the future, it would be very interesting to know if the governing bodies are keen to provide guidelines or even regulation for what's going on in the future. Who want, Jérôme, you have please take the floor.
Yeah, thank you. I think it's an excellent question, because when you look at what has happened, everybody relied on force majeure, which we all rediscovered somehow. And everybody thought that on force majeure you can basically do everything, but it's not as simple as that. I think in the future, yes, in the regulation, those who are missing this provision, what happens if we interrupt the league will probably include it in there. When you look at what has happened around the world for the 9 or 10 leagues which interrupted their competition, everyone did something different. Like not one of them did the same thing as the other. I mean, France, they did promotion and relegation, Scotland also, by the way, but the Netherlands and Azerbaijan, they did not. In Mexico, they decided to take the opportunity to go to a closed league. It's very, very different from one league to the other. And that's why what you're saying, Patricia, on FIFA deciding for everyone, we discussed the opportunity to do so, and we very quickly concluded that it was really not a good idea to do that. First, because we asked ourselves the question after some made already that these decisions. So the only thing that we could have said is basically it's the subsidiary principle should apply. And then because of the situation is very independent on what the government decides, it's very difficult for FIFA to interfere in that.
Ronan, there is another question. Go forward. Your mic, Ronan, we can't hear you.
Sorry. Yes, we have a question from Natalia Aranda about, I think, the resumption of the Mexican League.
Oh, hello. Thank you for having me. I really appreciate these spaces and to learn more and to express ourselves. Well, as you may know, or some of you may know, the Mexican League just decided to resume a new tournament because they canceled the previous one. We have 2 short tournaments instead of a long league as the European countries. So what happened is they canceled the last tournament, and then they decided to resume the new one or start a new one in 25 days. But what has been happening is that many of the professional players have been diagnosed with COVID for the past 2 to 3 days. There's one team that has 11 players that has been diagnosed with the virus. So I was wondering if there's a legal tool to prevent this, like the league from starting, regardless of the health criteria, because the government is just being negligent with everything from the start of the pandemic. So I think not only the players are being endangered, but the rest of the system and everything.
Thank you, Natalia, for your very interesting question. Maybe Loïc, you have a view about that?
What will be interesting, I think, in this sense is to what extent can players go to court to argue that the duty of care of employers has been breached. I'm not an expert in Mexican law, obviously, but I think this could be an angle, especially when there is very little involvement of players in the return to play protocol. Because in principle, when you have 25 players or players plus staff testing positive, the consequences should already be foreseen in the negotiated return to play protocol. So the discussion should not even be such an issue. It means there is a problem beforehand. This we haven't seen yet, players taking those steps. And it's actually, you have two angles mainly. They could go under, of course, the employment relationship angle, but and they could also go under tort law and request damages for any damage they suffer. But at this stage, it's still a bit early to see that.
Can I add something? Because I think it's a very key question, and you would, Natalia, you could understand with this question why what leagues have been deciding throughout this crisis is very dependent on government's policies. Because if a government says we're not going to close clubs, you can go out without masks and let life continue as if nothing happens, it's difficult to ask football to close down everything, because then you close down stadium, you tell people, you tell players not to play, but then they can go out to clubs. See, so what football is like any industry, it's very dependent from the government policies, and government needs to act responsibly to allow football to act responsibly also and have the proper protocols. You see what I mean? So so I hope they will, the Mexican government will realize what's going on, and then football will be able to implement the proper protocols, because we know we have protocols and we know what they should be like.
I think that we are a little bit late, even if it's very interesting. It's a good transition to go to the next round table, because the players and players are the core of this issue, and there are ongoing legal disputes. So all of us, Jérôme, Pedro, Christophe, and Loïc, you can stay there, and I think that it's time to hand over to Daniel CRAVO and to start the second round table, even if both are linked, as we have seen. So thank you very much. Daniel, go forward. You have the floor now.
Well, Daniel is not with us right now. I'm sure he's going to join very soon. But we have already Erika, MONTEMOR FERREIRA from FIFA. Thank you, Erika, for being with us. It's greatly appreciated. So you will share the floor with Daniel CRAVO, who is going to moderate this roundtable. Roy Vermeer from FIFPRO, and Alexis, a lawyer from Switzerland and an AIAF member. So I will try to connect everyone. If I try, that everyone is with us.
While they join, I'll say that it's a pleasure to be here. Nice to see you all. And especially, Patricia, remember that almost a year ago, I was supposed to be with you.
Yeah.
And then for health reasons, I couldn't. And so
yeah, I remember.
I'm really happy to be here today and join you in the discussion.
Very happy to have you on board. Thank you very much, Erika, and hope we can see each other in real. So Daniel is not here. If he is not, do we think we have time for other questions? Or should we wait for him?
I think he's connecting.
Ah, okay.
Roy is with us. Hi, Roy. Alexis also, and Daniel is going to arrive. Roy, can you hear us?
Yes, Rowan. Hi, I'm here. Thanks for having me.
Great. Alexis?
Hello, everyone. Can you hear me?
Yes, perfectly.
Perfect.
And Daniel should arrive.
What time is it in Brazil?
Well, Daniel should be with us. Maybe Roy or Erika or Alexis, you can maybe give a short overview of all the ongoing legal issues. Maybe before FIFA first, and Daniel will jump in as soon as he's available.
Sure. Oh, he's there.
Oh, sorry.
Hi, Daniel.
Huh.
How you doing?
Hi, Daniel. We were worried about you. It's lunchtime.
I've heard you call my name, but at a certain point, Hona changed my status and I was not able to interact anymore. I don't know what happened.
My bad.
So you're welcome. You have the floor.
Thank you. Thank you very much. Thank you, Erika, Roy, and Alexis to join us. Thank you, Patricia and Ronan, for all the great job to organize this meeting again. And I hope every one of you and everybody that are joining us at this webinar can be the safest as possible within this very difficult and I would say dramatic scenario for us in Brazil. We didn't even reach the peak concerning the consequences of the contamination by COVID. So I think we're still gonna have hard times in front of us, and of course that will impact in football. So I know that Erika has a lot of work already in front of her. Also Roy and all of us as lawyers that we work in this area, but I'm quite sure that we're gonna face much more challenges in the closer future with the transfer windows and everything that is coming. So in order to make the most with our time and to take advantage of the knowledge of our speakers, I'd like to, first of all, beginning by refreshing your memories, and I know that every one of you are quite aware of the content of the guidelines that FIFA issued and that FIFA built after consulting with many stakeholders and with a very important protagonist for FIFPRO too, in regards to particularly to the validity or not of unilateral variations of the contracts. So we saw clearly in the guidelines, and it was reinforced in the FAQs, that in principle, and that's the core idea, if I'm not mistaken, in principle, when it says that will be recognized only the unilateral variations or changes of the contracts if they have a legal support within a domestic level, or if they are also supported by binding collective bargaining agreements or similar instruments. So when the wording says recognize, I think we can all agree that we are speaking about validity of these changes. Okay, so if we agree with this premise, we're discussing if these unilateral changes are valid or are not valid, and which are the consequences of recognizing this validity or not. However, after stating that clearly in these two instruments, it is open the door to FIFA, at least within its jurisdiction. And I'm not here saying that it's correct or not, but I'm saying that it's open the door when FIFA says that although they are unilateral, if they are made in good faith, they are reasonable and proportional, and then you have the 5 criteria to be followed to scrutinize if these circumstances are met, then maybe these unilateral changes will be considered valid. So this is the premise that I wanted to ask you, which would be the consequences of recognizing the validity of such of these unilateral changes if they are lacking the support of the collective agreement or the legal. And just one comment. I know, and I saw Emilio's and Patricia's first intervention, and I promise you that this is going to be the longest one that I'm going to make just as an introduction. And I saw that Patricia said that many of these instruments, the guidelines and so on, are just guidelines, recommendations. However, in my understanding, some of them can be binding if we're speaking about FIFA jurisdiction. So I just make this comment to ask you, for instance, Eric, beginning with you, Erika, do you think that in a case, and I know that you're speaking hypothetically and you are not part of the DRC, for instance, hypothetically, if any of these unilateral changes, for instance, made by a club, and specifically regarding reduction of salaries unilaterally, okay, is made by a club, do you think that if FIFA enforces that, that would be according to the Swiss law, and that would be enforced by a CAS decision?
Hello, Danielle. Nice to see you. Thank you for the questions. Of course, this will be here my opinion. If you want to hear opinion of one of the members of the DRC or the PSC, you can revert to Roy. Roy, nice to see you. No, but jokes aside, as Emilio said, and I don't want to repeat myself too much, but again, these are recommendations, and they're all being extensively discussed among the football stakeholders. And I think it was very important in moments like this that we try to find a harmonized way on dealing with all the aspects. Again, of course, as to the DRC and the PSC in employment-related disputes, what we're going to see is that the variations they will not be recognized per se, as we are saying, but actually this will be discussed in unilateral terminations. I don't foresee that any club or player will come to us to recognize a variation, but it's rather if after a variation has been made, this leads to a unilateral termination, this will end up before the DRC or the PSC to discuss. As we said before, we're going to touch on this. We already received some claims. There are no decisions yet. But let's say that until now, the majority has been unilateral terminations, period, and not unilateral terminations resulting from a variation of agreements. So this is still to be seen. But again, I think it's important to see here that according to the rules, and we even have consulted also Swiss lawyers on this, unilateral variations, they can be analyzed and might be considered valid or not, proportionate or not. And here I will quickly get with Article 25.6. It says this can be taken into account by the DRC, CBAs and national law and the agreement between the parties. So this could be in the specific times. Again, we're not changing here the RSCP, and you saw in the FAQs that still RSCP will apply for terminations, but for the unilateral variations, it can be considered by the DRC within the scope of their members as deciding body. You have muted. Sorry.
Thank you. Roy, what's your view on that? Do you think that these unilateral variations, if it comes from a club, the decision to, first of all, thank you for joining us. I'm sorry. So do you think that it's unilateral variations, if it's a decision of the club in regards to reduction of salaries, how would it be accepted, or is it in accordance with the Swiss law? How do your expectations, I mean, on the side of FIFPRO, although I know you are a ruler if you are on the DRC, but on the view of the players, would that be acceptable?
Well, I think first of all, in relation to the Swiss law, the FIFA DRC doesn't really apply Swiss law per se. I know at CAS they have a preference for that, but as you know, at the FIFA DRC, the FIFA DRC normally applies the general principles of law. Now here we have a document which is agreed upon between the stakeholders, so should also be applied and should also be, that spirit should be taken into account should it come to CAS. Now, if there is a unilateral variation, of course we have to look at the document we created and follow a little bit what is in there and follow, have they tried to find an agreement? Is national law saying anything about it? If national law is silent on it, and if no collective agreement with a players' union is possible, which in certain countries, as we know, there are no player unions, okay, then the document says there is a possibility, if there is of course, a financial need for it. It doesn't give a carte blanche to clubs to arbitrary vary or reduce salaries, which some clubs have interpreted it like that, but of course there needs to be a financial necessity for it, which in the end, serve the purpose in the sense that it's also not good for a player to have his club go bankrupt or disaffiliated, which we have seen in the last 10 years so often. So that's why we give a little bit that lenience. So there will be probably situations where that will be accepted by the FIFA DRC, but there is a line to follow, and there are criteria to comply with by the club to prove that they have done everything in their power, and that it's a necessity that these unilateral variations are being applied. But from my experience, I've seen a lot of bad examples. So it's going to be an interesting time in the DRC, that's for sure. You're on mute again.
It's Hona. Hona is. Alexis, I'd like to have your view on that. I would ask you, per se, a unilateral variation made by a club, for instance, which is the, let's say, strongest part in the most of the agreements made between clubs and players. This kind of reductions, unilateral per se, do you think they could be considered against the public order according to Swiss law? Or do you think that, as Roy says, and here I think we have to applaud the sensibility of FIFPRO in this discussion, you cannot simply contribute to terminate the club, otherwise there won't be employees anymore. But do you think that there would be a question of balancing to see if it was applied according to the guidance, the guidelines, I mean, in a proportional, reasonable, and in good faith? Or do you think that per se we could have maybe or potentially something that violates the public order according to Swiss law?
Hi, Daniel. Thank you very much for the question, and thank you for AIAF to organize the conference. It's a great format, and I think it's good that we adapt to the situation. Excellent question, Daniel. And as a lawyer will answer, it depends, obviously. And why it depends? Because there is a before COVID and there is an after COVID. And the situation with FIFA is very clear. They've tried to set up a document, a guidelines, which is actually extremely well done, I believe, considering the very short time they had to do it. And they have tried, and I think they've somehow done it successfully, tried to take into account as many situations as possible. But obviously, after the FIFA level, the FIFA jurisdiction, there is CAS. And Erika was right that, or I can't remember if it was Erika or Roy, they mentioned that CAS arbitrator, they kind of like applying Swiss law. And we can understand that Swiss law may give a kind of a somehow stability in situation like this, simply because we might have, after the guideline, an application of a legal system that will not create big differences between the situation. But to get back specifically to your question, I'm not so sure that the first point is a question of public policy, but it might be first a question of somehow employment law or of the code of obligation that might apply at least as a guidance. And you will probably not be surprised to know that a situation like this never applied before. So there is actually absolutely no decision, either by the Swiss Federal Tribunal or even by cantonal courts that said, okay, you have two parties in a contract. None of them can basically, let's say the player cannot play, so he cannot provide the part of the performance that he's supposed to do. So as an employer, do I have still an obligation to pay him or not? So it's as simple as this. And all the situation we had before, it was a specific application of an article which is 324 of the Swiss Code of Obligation, which said, yes, the employer needs to pay an employee, even if the employee is prevented to work without his fault. But in a situation like this one, where basically it's the fault of no one, and when the circumstances are just so crazy, a lot of legal authors and very famous one in Switzerland consider that maybe this specific provision cannot apply in this case, but it might be a bit more like the, let's say, doctrine of impossibility to apply, which is, as you certainly know, Article 119 of the Code of Obligation, and CAS is applying it very frequently, where basically, too bad, the contract is here, but nobody can execute it. So in theory, we can imagine an employer raising this provision by saying, there is no counterpart to the contract, so I don't necessarily have to pay.
Okay, thank you. I think that I won't be able to summarize everything that you said because you are an expert in Swiss law. I'm not. But you bring the idea somehow of that very dangerous concept that in very good faith and concretely that's what we're facing. FIFA recognized since the beginning that we are in front of force majeure. So let's not go to that now because we would spend all the time discussing what the consequences of trying to scrutinize this concept and the use of it, of this recognition. But I think that is linked to the final words that you said. I mean, until which extent one or another party is able to comply with their obligations. So, but let me just touching again the point that maybe we'll have to, as Erika says, FIFA doesn't declare that it was valid or not an unilateral change of a contract. That will be addressed, particularly in cases where you are charging salaries or you are terminating a contract for overdue payables or under Article 17. So my question, Erika, for you first is, if you keep in mind that might be some discussions about the validity of a unilateral reduction of salaries, okay? My feeling, and this is my feeling, and I want to know if you guys at FIFA have already think about that. I clearly see that you can have some difference of discretionary power of FIFA between Article 12 bis and 14 bis, and why? Because in the range of the sanctions that you can apply according to Article 12 bis, you can be more discretionary, let's say like that. While when you go to the wording of Article 14 bis, it says that in case of a club unlawfully paying a player at least 2 monthly salaries. So do you agree that there's a difference between the discretionary power to FIFA be somehow more understanding, more sensible, more lenient to a unilateral action from a club? I'm not listening to you.
Sorry.
You want me to rephrase it?
Yes.
I can. Okay. The thing is, the validity, if it's valid or not, a unilateral reduction, a cut on the salaries, can have impact in different cases before FIFA, particularly if you are a player charging salaries or if you are terminating the contract allegedly by just cause, okay? Article 12 bis, you're speaking about overdue payables. And you have a range of sanctions that you can, as FIFA, although you have a jurisprudence already, but you can have such kind of discretionary power to apply more soft sanctions than you did in the same situation in the past, even if you have doubts that this reduction follow the criteria that are in the guidelines, or if we have doubts that it could be contested before the CAS. But then you have a range of options of sanctions to apply. So do you agree that you have more space to work with your sensibility? I mean, that FIFA bodies would have more space in 12 bis than in the 14th bis, since the 14th bis brings the idea of unlawfully paying, and then you have to discuss deeply if this reduction, it is valid or not?
Look, honestly, I haven't thought about that. But look, I still think that in any case, when you're talking about this for 12 bis and also for 14 bis, we were talking about when the parties had agreed, because if they haven't agreed in this reduction, or it's not really proved that under national law this is possible, I don't think we could say in a 12 bis that is a prima facie. And we're going to have, I think the members of the DOC will have to analyze that. But honestly, I see more coming to us when there is a termination after a variation. Because if the parties had agreed, or if the national law has proved that, then the club can come and prove to us that this was actually possible. Again, I think this will be up to the members of the DRC and the PSC, because it's not up to the FIFA administration. And I think in general, we're all going to have to take into account the specific circumstances of COVID and have some kind of flexibility in understanding all the issues. And this is still to be seen. I could have a personal opinion here, but I think it's more up to the members of the DRC, and probably Roy will have a stronger opinion on that one.
Thank you. Roy, what do you think? There's a larger, I mean, discretionary, it's easier to FIFA to handle this sensibility, not applying, or applying a more lenient way, more softer way, the sanctions of 12 bis, than to apply the 14 bis?
Well, I think I'm not sure if I understand the difference, because like either way, someone needs to analyze and make a decision if the unilateral variation is valid or not. So if you've been paid March, April, May 50%, and a player files a claim for 12 bis, someone will decide if that unilateral variation was valid or not. If it was, then there's nothing, right? Because the player won't get anything anymore, there won't be any sanction. If it was not valid, then the player gets his money, and there will probably be a sanction on the 12 bis, which are already not too harsh right now, but maybe in this period, the judge will go, okay, instead of the 5,000 Swiss francs fine, we do 1,000 Swiss francs fine. On the 14 bis, you're normally speaking about a termination, right? So if March, April, May, and June have all been paid for only 25%, more than 2 months' salaries could be outstanding, and you could potentially terminate the contract. Then again, they have to the judge will have to analyze if that termination is valid or not, taking into account the validity of the unilateral variation. If it is a valid unilateral variation, then probably the player doesn't have a just cause to terminate. And if it wasn't a valid unilateral amendment, then he does have a just cause to terminate the contract, and compensation will be due. Probably again, no sporting sanctions, as it's not applied or imposed very often. So I think the two, 12 bis and 14 bis, are very similar, very different in nature. 12 bis is more the outstanding salaries termination agreements, where 14 bis goes into the termination of a contract. But in the end of the day, it's always a judge having to analyze whether the unilateral amendment was valid or not. Whether that for sanctioning makes a whole lot of difference. 12 bis is more likely, actually always should impose a sanction, where in 14 bis there's rarely any.
Okay. Alexis, as a lawyer, my concern, and I think that this door opened by FIFA by considering unilateral variations as valid, that's an open door. I think that it clearly gives to all the parties involved, and us as lawyers, we have, I think, the duty to make more, to emphasize even more within this context to our clients that don't jump into a termination allegedly with just cause. Either you are a club or a player, because it's not clear if the club, especially if you are as a lawyer of a player alleging that there is a breach of Article 14bis or 17 because of non-compliance of salaries, of the entire salaries, because of a reduction. I think we are in a very moving sand at this point now. But my question to you is, considering that the consequences of the application of Article 17 or 14bis, in my point of view, they are deeper than 12bis, because it brings together the termination and it ends the possibility of the club profiting with a future transfer, and also has the compensation for the breach. So in this sense, what would be your advice to a player, for instance, within these scenarios, within 3 months that been paying much less, like say 50% of his income, in view of unilateral deduction? Would you tell him that, and I know this is not a fair question, but would you tell him, okay, let's go, there's another club that you want to be transferred, and here you have a chance? How will you act? How will you answer this consultation at this moment?
Good question. Thank you. Thank you for this one. I remember that, Daniel. No, to be honest, I can say it on very simple angle. As I said before, there is a before COVID and an after COVID. And also as a CAS arbitrator, I will be really sensitive for a lawyer to come with a client trying to act somehow in good faith. And that's really get out of this document made from FIFA, where there is no position which is black or white. So basically, as we said before, whether an unilateral modification or variation of a contract is valid is one question. But the other question is to what extent the variation applies. Because if the variation is like, let's say I reduce 20, 30, 40%, I'm not sure anyone should complain about it, right? I think even a 50-50 modification could still be somehow fair, unless you are really at the bottom of the salary pay from the club and you have difficulties to live somehow. So I will basically be quite reasonable on the player side before terminating the contract, because then you have the big risk. It's a unilateral decision to terminate the contract, so you cannot go back to the club and say, oh, I changed my mind, finally I want to stay. So I will be really, really careful with that. And there is something I would like maybe to ask as a question to Erika and Roy. Maybe you have seen that BAT, the Basketball Arbitral Tribunal, they have issued some, let's say, similar guideline, but they've already put some kind of scale of how much a reduction was possible. So basically, if you have this level of salary, it could be this. Did FIFA actually thought about it, at least for small salary? Was it even discussed?
From what I recall, that was never discussed, no. And I think, look, I don't know the exact situation in basketball, but of course there's a lot of player unions around the world in football. So we've also always said the core of the negotiation should be on national level between the players union and the club association or the league in that particular country, which in a lot of countries went quite well. In the Netherlands, in France, in the US, in Denmark, they found agreements either on a club level or on a collective level. So I don't think that something like that would have, I cannot recall it was proposed, and I don't think it would have worked from a FIFA perspective, as the differences are also so big in those in between countries.
What I can say, I wasn't in the beginning of the discussions, but as far as I can recall as well, Roy, maybe Jérôme is still there to say something. There was no such discussion, no such topic on the table. And as we said, we had to find recommendations and guidelines that would be applicable to all the 211 member associations. So it is very difficult to find a solution that will be tailor-made, considering all the different scenarios and discrepancies worldwide in football. So I don't think this would be possible to find an agreement between the stakeholders to impose such specific decision.
Thank you. Erika, what would be the role of the national law in cases of unilateral terminations related to COVID, basically? Is there any study about that, any perspective?
Look, I think this was one of the topics that were actually, after the guidelines were released, were published. And as Emilio explained, we had sessions with all the different member associations. This is one of the questions that appear many times, and that's the reason why it was included in the FAQs that was published latest. And basically, is to clarify that regarding lateral termination, nothing has changed as the jurisprudence of the chamber, and that still RSTP will apply to lateral terminations. So this has been the established jurisprudence since the beginning of the creation of the dispute resolution chamber, and this remains the same. What has changed here is only that whenever termination is result of a unilateral variation, this unilateral variation will be analyzed by the members of the DRC vis-a-vis what the guideline said, which is, first of all, is there a national law that had allowed for this variation? And then if not, and again, it's up to, of course, of the parties to prove this and demonstrate, and as you saw, have a legal opinion or some sort of explanation on why this rule applies, and otherwise, then following this criteria. So basically, national law only plays a role in the variation, unilateral variation of the agreement, and not on the unilateral termination itself. And this, as I said, in Article 25.6 of the RSTP does say that the DRC and the PSC, I will read here, shall, when taking their decisions, apply the regulations and take into account relevant arrangements, laws, and or collective bargaining agreements that exist at national level. But this is for the unilateral variation. Still for unilateral termination of the agreement, we will apply Article 17, and the normal jurisprudence of the DRC will apply. Of course, as we said, there's before and after COVID, and this will be taken into account, but basically RSTP will apply for termination. And in this, we still not have any decisions like the BAT had, but we'll soon have in July a DRC meeting and a PSC meeting with already some cases related to COVID.
it's going to be interesting to see these decisions, because usually we see, at least to my knowledge, that we see that we apply the domestic provisions if they are beneficial to the player, as it happens in Ariosa's case, when they are conflict with FIFA rules. But in this case, we don't know what's going to happen because it's a very exceptional circumstance. Thank you, Erika. Just taking advantage that you are still there, with the floor. That which kind of can you tell us broadly, generically, which kind of issues have already been brought to FIFA related to COVID? More Article 14Bs, 12Bs, 17. Which kind of issues have already been filed before the FIFA decision-making bodies?
Again, of course, I cannot discuss details, but in general, we already have, so for the next meeting, which will be DRC and PSC, in July, we have already 20 cases to be submitted. And so far, they've all been unilateral terminations. So not related to 12Bs, but mainly unilateral termination, some of them invoking 14Bs and the others no. And in this respect, if I can recall well, just one of them actually invokes a unilateral variation previous to the termination. The rest are basically unilateral terminations and invoking COVID. And here we'll make let's say a split, because there are cases that are already pending, and then the argument of COVID comes, but since they're not really related to COVID, but it's like the financial hardship, they're not being considered strictly related to COVID-19. So I'm talking about the cases that were lodged after the pandemic starts, and they are, invoking as being a result of the termination because of COVID. So this
I'm
is
aware that some Brazilian clubs try to use these arguments in a fair way. Okay, Roy, did you receive many questions or requests from players all over the world that led you to orientate them not to take any precipitated actions, like serving a notice to the club while the player is not able to travel back to his home country? Which kind of precautions, did you have already received any consultations that you have to make a strategy or to orientate a player before he takes any measure against the club that reduces salaries, or in this sense?
Well, yeah, we had, our player unions on national level had, of course, quite a few, and then every now and then they come in and they ask for advice. I think a few of them, which were specific to this period of time, were players who weren't paid for a long period of time already before COVID, wanting to staying in the club's accommodation and wanting to send a default notice of terminating the contract. And where you say, okay, well, we know a little bit the reputation of the club. Perhaps it's not a good idea to send the default notice or termination, especially the default notice now, if you're basically stuck in this foreign country, right? Because we have seen cases where players are being evacuated from their accommodation of the club. So we had some players in Guinea which wanted to send the default notice. Well, you cannot go back to your home country, so probably wait a bit, because if you send the default notice, we don't know what's going to happen. We had that in Bangladesh as well, and in some other countries where we said, okay, let's be a little bit more patient now. And of course, we have had players on unpaid salaries who were stuck in a foreign country, couldn't leave, and are still there right now, who haven't been paid the last 3 months, contract already expired, and are still forced to be there because the club didn't pay their flight ticket before the COVID started. So there's some really nasty stories there. So yeah, but plenty of work, so don't worry about that. There's plenty to do.
No, I've been experiencing as a Brazilian lawyer many situations as the ones that you've just described, and it's horrible. And I wonder if somehow we could, or we should, I mean, we all should tackle these issues, these abuses in another way. I mean, in using the ethics rules. I mean, to prevent these persons that are officials of these clubs or federations to keep using this approach, because this is very unhuman. It's something that it's outside a simple violation of the contract, in my point of view. Alexis, one question for you specifically. Do you mean that if a player, and I don't know if any one of you have already received or seen any case like that, or at least a potential situation like that, if a player refuses to play? I mean, in Brazil, we have different authorities within the city level, the state level, and the federal level, with different approach concerning the resume of the football activities. Within this context, it would be, in principle, reasonable to a player say, listen, if you cannot understand all the entities of the state, I'm not sure that I should resume my activities, putting my family in risk, for instance. Do you think that this player have legal grounds under Swiss law, or do you think that the CAS approach in a situation like that, if the player is dismissed by the club, if the contract is terminated with just cause alleged by the club because the player refused to rejoin its activities, is sustainable? What do you think about that?
Yes, I think it is. I think it is. But again, it has to be taken into the, let's say, the overall context. I will say, for instance, I will talk about what I know. In Switzerland, the situation is now more or less safe. So I think it will be pretty hard if measures are put in place to protect the health of a player, for him to just refuse to play. You know, for instance, if all the other players are tested before. So if there is all this guarantee, I think it will be pretty difficult. But in other countries, when the overall sanitary situation is more questionable, definitely there is a ground. But again, as you know, and you know it better than anyone, the player will have somehow to prove it. Basically, it will not be also that easy, depending the situation, for the player to express that he felt so unsafe that he could not play. Basically, another ground will be for a player maybe just to go to a doctor and fake a cough, or you know, there is many other way. And again, we were talking about the player before terminating the contract. That will be really risky. I will not advise any club at this moment to terminate the contract with a player because a player refused to play. That will be, I think, really a pretty dangerous idea from a club.
Okay. On the other hand, yeah, Erika, you can answer, but then I would add something else. The other face of the coin. If a club make a lot of pressure, implicitly or expressly, to return to the activities, although the players don't feel safe, and let's go to the extreme, some player is contaminated, and in the end, unfortunately, of course, this player dies due to the COVID. Have you discussed, at least brainstorming about such of these situations, you and FIFPRO or the other stakeholders?
Look, definitely, this was not in the table. Roy can correct me if I'm wrong, but not to this extent. But what I was going to add is actually that I don't think much has changed. Of course, we need to think that it's COVID and we were not ready for this. Nobody was ready for the situation and the discussions. Look, after so many years already here, every day was a different challenge, questions from MAs, the stakeholders discussing. So I really think it's one moment to think outside the box. But what I was going to say related to the last comment of Alexis is that at the end of the day, I don't think not much have changed, in the sense that for the DRC and for FIFA and the deciding bodies, the determination of a contract should be the ultima ratio, meaning that the parties, and this is in line with the guidelines, should try to find a solution for such a special moment, particular moment with so many challenges. So either the player or the club is not about advising, but of course the DRC, I think Roy will agree, will think that it must be a ultima ratio and it cannot be, oh, COVID, I'm terminating the contract. So that's why also they will have the burden of proof to demonstrate whether or not there was a reason for terminating the contract or for doing a unilateral variation that led to a termination.
Roy, any views on that?
Well, I think if a player doesn't want to play for health reasons, the club must respect that. Players have the right to private life, which also includes the right to a physical and psychological integrity. And I think, you know, we've seen in England, for example, Troy Deeney and Kante, who were reluctant to play at the beginning, and the clubs were reasonable with a reasonable stance. I haven't seen any disputes where the parties are really against each other on this issue. So I'm not sure if it's if it will come to that. I think, but I do think that there is a humane stance to take from the club if a player is genuinely feared about the consequences, and understandably, I would say so. Then they just need to speak with each other and find an agreement how to deal with it. The extremes I haven't seen yet.
Okay. Ronan, do we have time for one more question, or?
Well, I would say that it's up to you if you still have some. I think Patricia had a question.
Can I raise the last question here for the panel? I mean, there's time, or we are.
Daniel, let's say that we are going to finish in 5 minutes, if it's okay.
But with more questions, or just 5 minutes?
No, I would say, well, 5-10 minutes. You know, it's
okay. Very quick then. To the three of you guys, please. Do you expect many problems and issues concerning the return of loans and the extension of loans, considering that somehow, and I know that the stakeholders, FIFA, FIFPRO, you work hard to try to find the best way that you deem to solve this situation, aiming to preserve the principle of the integrity of the competitions, basically, and knowing that the contract is the core of the relationship. So trying to balance both, but recognizing that the core is the contract. I think in the end, FIFA adopted a kind of strict approach by not permitting the return of the loans outside the transfer windows, right? So considering that, do you expect, Erika, and how Alexis and Roy sees that the problems are coming, do you expect that there will be a lot of exemptions being asked, requests made to FIFA to register the players outside the transfer windows in the federations of the clubs that has the definitive link of the player?
Yes, I do think that this will happen, and that has been discussed in the guidelines and in the FAQs, and it was given the administration also this discretionary to check a case-by-case basis, and I think we're definitely going to get more and more. But as we said, we did the guidelines, we asked all the parties involved to find solutions and encourage them to extend contracts and loans. But again, FIFA is not a party to any of those agreements, and at the end of the day, the parties will need to find a solution. And as you saw, there was an amendment to the regulations as an exception for terminations that are due to COVID, and then they can ask and do this exception. But again, I'm sure there will be plenty of scenarios that maybe were not foreseen and that we will have to analyze.
Okay.
But this is honestly, Roy?
From what I mean, I don't have the document in front of me. From what I recall, we actually made an exception for loans that players can return regardless of whether the registration period is open. But I don't recall that at this moment, but I'm quite sure that we did that.
Alexis?
Yes, I have the impression that the guideline are pretty well done in this aspect, because it still gives some flexibility to adapt to situation. While if you had a really strict guideline or like a rules, that would definitely lead to a lot of frustration. Here, it gives the impression that there is a way for the parties to find a way based on their specific situation. So I don't see really an interest for the party to go into long fights in this kind of scenario, to be honest.
Okay, just to mention one point, because I know it's not just mine, is that the only concern that we have is that if you are trying to convince the club that has the player on a definitive basis to agree with an extension, this club will only agree on that if he's sure that the player is able to return when the transfer window is open in his country. Because otherwise, this club that holds the definitive link with the player will have to receive the player without the ITC being received, which means we'll have to pay the salary and cannot use or register the player. That's why one of the options that I've been discussing, and I know that Horacio Pintos brought in the discussions with the stakeholders of FIFA, would be just for the return of the loans, keep the windows opened indefinitely, or at least until the middle of the next year, just for the return of loans. Otherwise, it's going to be very difficult to, for instance, an European club that wants to convince a Brazilian club to extend the loan until the end of this current season. This being said, Ronan, I think we're going to open the floor to the questions, right? And since I think it's going to be my last participation here, I would like to thank you very much to Erika, Roy, and Alexis. And I'm sorry for not sharing with you all the questions specifically before, because I honestly didn't have time, but I was sure that you could bring a lot of knowledge for all of us. Thank you very much.
Thank you, Daniel. I think it was very, very interesting. And if we look at the FIFA Q&A, there is this sentence very interesting, and you pointed out, there is a risk that the player may not be registered for a significant period of time. So it opens, as you said, a risk. What risk? And a significant period of time. But as Alexis said, what could they say more? The door are open, and for us as a lawyer, is very, very interesting. Take apart that it's a terrible situation for people, but it's very interesting. So,
Patricia, just one mention. I think, and I'm quite sure that this sensible approach of FIFA will be felt in these situations by granting exceptional registration, okay? But that would mean that you have to be submitted to all the procedures of a special authorization. It's not going to be very fluid. So this is the argument. I think that FIFA will act reasonably, because if the clubs, both clubs involved, took into consideration that the club that received on a loan needed the player for more time, you're not going to penalize the club that will suffer a burden. So I'm sure that FIFA will be sensitive to that. But although you have to be submitted to a procedure instead of simply depending on the clubs and the TMS system, that's just my concern.
Right,
Sorry.
yeah. No. Thanks. Okay, it's okay. Very, very interesting. So maybe some words to conclude this first day. I don't know if Erika or Roy or maybe Jérôme or Loïc, you want to say some words to conclude? There is many other questions, and we don't have time, but these questions are still open, and then you have also the opportunity tomorrow. We'll look at the tomorrow football. But Erika, you want to say some words to conclude?
Yes, sure. So it's just, again, regarding the exceptions for return of loans, if you see, so number 26 of the FAQs explain what is this result of COVID, and thus explains where the end of the season is extended and the loan is extended. So I think many of them were already in there, and what is not there, we're going to have to analyze case by case basis. And you can check with Jérôme and Roy, not only with the FAQs, but also we receive many requests from MAs, and we've been reacting on a daily basis with all the questions and validation exceptions and manual and changes of seasons requested by the MA. So really being coordinated among TMS and player stages. And I think the response has been fast, and we'll continue to do that as much as possible. And to basically say, I think I've been in FIFA, you know that before, and then I went to AIAF and back. And I'm amazed by the response, by the workforce of both, you know, all the stakeholders and the response that we made possible. And then also on the player status side, that we were ready to continue the daily business and then the meetings, and everything is working as good as you can, of course, with all the challenges. And I also want to thank Patricia for the opportunity, and it's great to be here today and be discussing all the different, you know, challenges that we're facing, and see that we're all trying to find solutions for such a specific moment that we're all living in. So thank you very much.
Thank you, Erika. Roy, do you want to say some words to conclude?
Well, I'm afraid I've got nothing inspirational, so I will pause on the third story.
Okay, Jérôme, do you want to say some words?
Yeah, I'm not sure I have anything inspirational either, but you know, I think we're living very exceptional circumstances. That's what it shows, and those circumstances have an impact on all the aspects of our industry, the health, the financial, and also the legal. So for lawyers, it's also a very, very interesting times, you see. I think as far as this second roundtable is concerned, I believe it shows the importance of social dialogue, really, because in all countries where you can actually develop a social dialogue that's worthwhile, it gives legal certainty. And those who have doubts on the interest on social dialogue, I think this crisis show that where you don't have that, maybe it's time to develop it. You know, I see the whole world with the World League Forum, and I was amazed. I think the best example of tackling this crisis was in Costa Rica. They were the first one at actually signing an agreement between players and the league on how to deal with the crisis for all the players, all the clubs, and specifying the cases if the competition resumes or not resume. So social dialogue is really key. My second thought is on the importance of domestic law. And that's a very good thing that I would say at last, because I've been a long-standing fan of domestic law. I think it's good that at FIFA level, in certain circumstances, within the DRC, we take a look at domestic laws and not apply Swiss law with a blind eye on all the rest. And the last thought would be that we spoke about maybe the leniency of these new rules and of FIFA on that. I think we should see that as a flexibility because we will need flexibility as lawyers in the rules to be able to fine-tune the decisions to every case. That's basically my thoughts of this very, very interesting day, and thanks again for organizing.
Thank you, thank you. I think that these words, flexibility, social dialogue, will be outlined tomorrow in our next roundtable. Tomorrow, designing legal certainty. So to design, we need tools. So first, I would like to thank our guest speaker. I would like to thank the AIAF members who gave their time. I would like to thank all participants. Sorry not being able to answer all the questions, but it's very easy to get linked. And Daniel, one word to conclude. You have the floor. You have the floor.
It is impossible to choose the best speaker today because all of them were amazing. But there's a dispute that is just between Jérôme and Pedro MACIEIRINHA. about the landscape that they use to in their participation. Amazing.
Thank you all. Thank you, Daniel. Thank you all. Thank you, Ronan.
Well,
and see you tomorrow.
Tomorrow at 5.